Thank you very much. Let me take this opportunity to extend my thanks to the organizers of this important conference on human trafficking, and in particular Monsignor Sorondo for the invitation to present this paper. As already introduced, my name is Dr. Liz Mokobi, and I'm a senior lecturer at the University of Botswana. Two of my colleagues from Botswana have already spoken this morning, and what I intend to do is to speak with you about my area of interest, which is to inquire into the degree to which Botswana's municipal trafficking laws are compliant with her international law obligations as set out in the international instruments concerning the trafficking of persons to which Botswana is a state party. This topic, you will agree with me, is of utmost importance and should be considered by all nations which intend to have laws on the trafficking of persons. This is because our international conventions set out the gold standard, a set of rules agreed by nations to combat the scourge of trafficking. However, as you are aware, in many jurisdictions, the interface between international law and municipal law can be complex. Unless a country subscribes to a monist tradition where international law automatically forms part of municipal law, it is entirely possible that international law obligations that a country undertakes remain aspirational and unreachable by ordinary victims of trafficking within the national jurisdiction. This problem is most common in countries that follow the dualist tradition. In such countries, such as Botswana, international law must be taken through a process of domestication in order for it to form enforceable rights and duties. I'm sure that's the situation in many other countries here. It is not therefore unusual for some provisions of treaties to be ignored or watered down at the moment of domestication in order to present a more palatable legislative document at the municipal level. Obviously, there are many reasons that inform the departure from the express terms of treaties, and I shall not venture into those now. However, I will give some examples of treaty obligations not finding their way into municipal law from my own jurisdiction, Botswana. The first example, of course, perhaps one of the most notable, is the use of the death penalty in Botswana, but this is also in other countries in our continent. Botswana is signatory to several conventions that prohibit torture, cruel and inhuman punishment, and yet Botswana retains the death penalty as part of her municipal law. Another example, of course, concerns judicial corporal punishment. In Botswana, we have acceded to the Convention on the Rights of the Child, which expressly prohibits corporal punishment of children in all settings, and yet we still retain corporal punishment. The reason I point out these examples is to illustrate that international law conventions are not always given full effect in the municipal setting. And I'm sure this is the experience of some countries here as well. The purpose of this paper, therefore, is to investigate how closely Botswana's human trafficking laws adhere to her international law obligations. And I would suggest it would be an interesting inquiry for all the nations gathered here. One of the main international instruments to combat human trafficking is the Palermo Protocol to prevent, suppress, and punish the trafficking of persons, especially women and children, of 2000. This protocol supplements the UN Convention Against Transitional Organized Crime of 2000. Article 2 of this convention provides for the prevention of human trafficking and calls upon all states to protect victims of trafficking, to promote cooperation among states to combat human trafficking. Article 5 of the same convention calls on states to criminalize trafficking, attempted trafficking, and those acting as accomplices in trafficking, as well as the organization and directing of human trafficking. I'm happy to say that Botswana has ratified both the UN Convention Against Transnational Organized Crime and the Palermo Protocol in 2002. 3 international labor organization conventions contain provisions dealing with forced labor. The first is Convention number 29 of 1930, which requires states to suppress forced or compulsory labor. Botswana ratified this convention in 1997. The second is the ILO Treaty dealing with forced labor, and this is Convention number 105 of 1957 on the abolition of forced labor. Botswana ratified this convention in 1997 as well. And lastly, the Convention number 182 concerning the prohibition and immediate action for the elimination of the worst forms of child labor of 1999, which Botswana ratified in the year 2000. This convention prohibits all forms of slavery and practices similar to slavery, prostitution of children, the use of children for illicit activities, and work which harms the health and safety or morals of children. Botswana is also state party to the United Nations Convention on Civil and Political Rights since the year 2000. And this convention prohibits slavery, slave trade, servitude, and forced labor. Botswana is state party to the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, since 1996. And this convention prohibits trafficking in women and the exploitation of women through prostitution. Botswana is state party to the Convention on the Rights of the Child since 1995 and its optional protocol on the sale of children, child prostitution, and child pornography since 2003. As you've heard, these are problems that we're grappling with in Botswana. Both these conventions prohibit the trafficking of children for any purpose and the exploitation of children through forced labor. Lastly, Botswana acceded to the UN Refugee Convention and its 1967 protocol in 1969. The UN High Commissioner for Refugees has indicated that some trafficked persons may be entitled to international refugee protection if they are found to have a well-founded fear of persecution on the grounds of race, religion, nationality, membership of a particular social group, or political opinion in their country of origin. I will now mention the conventions that Botswana is not state party to. Botswana is not state party to the Slavery Convention of 1926 and its 1956 supplement, which prevent and suppress the slave trade and bring about its abolition. Botswana is also not state party to the UN Convention for the Suppression of the Traffic in Persons and the Exploitation of the Prostitution of Others of 1949. And this convention requires the criminalization of the exploitation of others through prosecution. Now to the last point of inquiry, which is whether these conventions that Botswana is state party to have indeed been domesticated and form part of our municipal law. In order to win the war against human trafficking, states must take provisions of these international conventions and make them their own. By this I mean that states must take steps to suppress, conduct, and criminalize behavior which would amount to human trafficking. Without robust municipal laws, rules contained in international conventions are merely inaccessible and ineffective for victims as well as law enforcement agencies. Human trafficking can be combated through a vast array of legislation from an immigration perspective, as well as legislation from a criminal perspective. These methods must be used simultaneously and not independently of each other. A human rights-based approach to the combating of trafficking is also of particular importance when paying attention to the situation of vulnerable victims of trafficking. This is to ensure that the most vulnerable people in human trafficking are protected. Victims of trafficking must be protected from the possibility of further victimization because they are already disadvantaged and are often in want of social protection. I will now illustrate how Botswana's municipal law gives effect to its international obligations. As mentioned by my colleague Priscilla, we have the Anti-Human Trafficking Act of 2014, whose purpose is to domesticate the UN protocol to prevent and suppress and punish trafficking, especially that of women and children. Under this act, trafficking of adults and children is criminalized. We also have laws that deal with forced and compulsory labor, which I mentioned was prohibited under the ILO conventions. We find these under the Anti-Trafficking Act, but also under sections 69 to 72 of our Employment Act, which prohibits forced labor. One matter I noted is that the penalties under the Employment Act for forced labor are significantly less severe than those you find in the Anti-Trafficking Act, and there's a need for rationalization of those. Slavery and forced labor of children and the sexual exploitation of children is also dealt with under our municipal law. We have, of course, provisions of the Human Trafficking Act, Section 2, as read with Section 9 and 10 of that Act, as well as provisions of the Children's Act under Part 16 of our Children's Act. Again, I must point out that there's a disparity in the penalties, with those under the Human Trafficking Act being much higher. Slavery is prohibited under our penal code and again under the new act. Lastly, I would like to mention that our Anti-Human Trafficking Act provides for the possibility for persons who are trafficked to remain in Botswana. Unfortunately, the Act does not specifically link to the Refugee Act, making it possible for such persons, if they are unable to return and if they qualify for refugee status, to apply to be refugees. However, the Minister does have discretion to allow such individuals to remain in Botswana. In conclusion, the question I posed at the beginning of this discussion was whether Botswana's municipal laws fully domesticate her obligations under international law. Indeed, I believe the answer to that question is yes. What remains to be seen is how effectively these obligations can be implemented by our government agencies. One emerging challenge that I have already mentioned is the need to rationalize the disparities that exist between the penalties across the various legislations that I have mentioned. I thank you very much for your kind attention.
Thank you so much, Dr. Elizabeth Macharia. And we now go to Cape Verde.
Sorry, one question. Congratulations, very nice speech. But you don't speak nothing about the trafficking of organs. You have problems, you have laws. What is the situation about organ trafficking?
Thank you. I'll answer on her behalf. She requested me. At the moment, within the country, we don't have a problem with that. But we have one case where a victim from Ethiopia was being trafficked for his heart. Fortunately, it was intercepted, and evidence showed that because he was an athlete, so he was being trafficked to South Africa for his heart. But we have problems of sacrifices, which is not that more, but we have amended our act to include sacrifice, because in the past, if you were found with a finger of a person, there was no law prosecuting you, or there was nothing that would prosecute you for. But under the current act, now we'll be able to prosecute you for that. So anything that we found, whether it's an ear or a nose or what, we'll be able to prosecute you for that. But before, we could not prosecute.